All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please announce the case.
La situation en République du
Court officer, situation in the Republic of Kenya. The prosecutor versus William Samuel Ruto and Joshua Arapsang, ICC 01090111. We are in open session, Mr. President.
Thank you very much. Appearances?
Mr. Prosecutor, Mr. President, the prosecution team has been joined by Mr. Lucio Garcia, trial lawyer, Mr. Lorenzo Pugliatti, associate trial lawyer, and the case manager today is Grace Go. The other parts of the team remain the same.
Thank you very much. Defense?
On behalf of Mr. Ruto, the team is unchanged.
Sang defense?
Mr. President, the Sang team remains the same.
Victims' counsel?
Mr. President, we remain the same. Thank you.
Thank you very much. Do we have technical problems with the transcript? I'm getting only the French. One moment, please. Thank you. We're back in business. So we will continue with the witness on the stand. The prosecution has re-examination to do. But before we do that, some sitting hours announcement. Today we will go through to 1 p.m. But then we will have only 1 hour lunch break from 2 to 3. We will adjourn at that time for the day. And on Monday as well, we will go until 1 p.m. and we adjourn for the day on Monday. On housekeeping matters, we will, I'm sure, as soon as Mr. Mofade completes his re-examination, we will return to the matter of protection measures for witness 268. Have the parties received the redacted report of the Victims and Witnesses Unit?
Yes, we've had the redacted report. Thank you.
The prosecution has as well.
Right. So we will take up that matter after the current... Oh, sorry, Mr. Kiginkatwa.
Mr. President, we have also received, but we will be raising an issue about the reductions, and we have given notice to the prosecution.
Yes, I anticipate we will have litigation on the question generally of the protection of the witness, and then if you have any other issue associated with it, we will discuss that at the same time.
Mr. President, can I just clarify page 2 of the transcript at line 19? As I understood, Your Honour, we're going to sit until 1 p.m. We will then resume at 2 p.m. for 1 hour until 3. And then at 3 we will adjourn for the day. Is that correct?
That's correct.
I'm grateful. I just wanted to clarify the transcript. Your Honour, the other matter I've alerted my learned friend is after this witness, I'll be making a short application that may touch upon the schedule for next week, or at least for Monday and Tuesday. But Your Honour, I'll make that later with your leave, but just to give a heads up.
Fair enough. We will now go straight to the prosecutor's pre-examination. Mr. Mofade, we are in open session. Witness, welcome back. Thank you for joining us, rejoining us today. Hopefully, this will be the very last stretch of your sitting there. You've sat patiently and answered questions. The prosecution promised that for 30 minutes they will ask you questions, and that will be the end of it for you. Hopefully that's the end of it. Thank you.
Thank you.
Mr. President, I actually anticipate that it will be less than 30 minutes.
Thank you. Please proceed.
Good morning, Mr. Witness.
Good morning.
I'd like to ask you a few questions about some matters that were explored with you by Mr. Hooper when he was cross-examining you. Do you understand?
Yes.
Mr. Mofade, you do know we're in open session?
That's correct, Your Honor. And the questions will center around the rallies that you attended back in 2007. Do you remember speaking about that?
Yes.
The first rally, which was not fully attended, as you said, was a PNU rally for Mr. Sebi. Do you remember speaking about that?
Yes.
You then spoke about an occasion when Mr. Kenyatta drove through Eldoret town with his convoy and he happened to address the crowd. Do you remember speaking about that as well?
Yes.
And then you came to the ODM rally, which is the last of those that you were physically present at, which was in December 2007. Do you remember speaking about that as well?
Yes.
Now, I'd like to ask you whether, now that you've seen the video that was shown to you by the defense team of Mr. Ruto, whether you maintain that the rally was at 64 Stadium or at Huruma Grounds. Which one is it?
I can say it was in Huruma Ground.
Is there any doubt in your mind that you attended that rally?
No doubt. I would like to say that all my mind and my recollections in mind, I had...
Wait. The question the lawyer is asking you, has asked you, is whether you are sure that you had attended that rally, which you now say happened at Huruma Grounds He's asking whether you are sure in your own mind that you were at the rally.
Well, I can admit I'm not sure.
Well, do you have any doubt that you attended a rally in December 2007?
I attended one, I remember, but
And do you remember the location of the rally, the ODM rally in 2007?
I remember I attended one, maybe. Since 64th Taliban, maybe. Let me correct that way, because I'm confused about this Bay rally and 64th Taliban, and there was another rally which was not political, but it was, I think it is DC who was there.
And just for the transcript, could you repeat the last thing you said? You said, I think someone...
District Commissioner, but that was not a political rally.
In any event, the rally that you attended, are you certain that Mr. Ruto was there and Mr. Odinga was there?
Yes.
And are you certain that Mr. Ruto spoke while you were present at that rally?
Yes, correct. He spoke.
And I don't want to ask you about hats or hammers or garments like the defense has. But let's focus on the words that were said. Is there any doubt in your mind?
Just a word of caution. This is re-examination. It's not a passport to leading questions, of course, and I'd ask my friend to be very cautious, given the evidence this witness has given.
And also, counsel, re-examination should not be understood by any side as to be an occasion to shore up examination in chief. After cross-examination, re-examination should be an exercise used to explore new matters that came up in cross-examination that were not reasonably foreseen or foreseeable during examinations in chief.
I bear that in mind, Your Honor, and this is all I propose to do. Mr. Witness, when you say you heard Mr. Ruto make the statements he made at that rally, can you tell us how the crowd reacted to this statement?
I'm sorry. The friend, I appreciate his difficulty, but he hasn't taken on board the necessary limitations here. We've had the defendant's evidence, the witness's evidence, both in chief and in cross-examination from the defence in respect of this, and revisiting those issues in this way, rather than, as Your Honour's clearly delineated, new issues, is not a function that should be discharged now.
Objection is sustained.
When you were questioned about this rally, you were asked repeatedly about the word grabbers. Do you remember that?
Yes.
And you actually gave a Swahili translation of the word you say Mr. Ruto used. I believe you said Wanya Kuzi. Do you remember saying that?
Correct.
And it's been suggested to you that grabbers refers to those who had been stealing money from the government. Do you remember that?
Correct.
But when Mr. Ruto made this statement and the crowd reacted, what did the crowd say?
They reacted saying that Kikuyu should go back to Central. That one I remember. Because it was, even that thing spread so quickly that even after the 2 or 3 days, everybody used to say that in another term.
And you know, just for the transcript, line 3 is they reacted saying Kikuyu should go back to Central.
But I believe that witness that testified to that before now, wasn't that the case?
Your Honors, I'm trying to elicit the reaction, the response to the suggestion that grabbers meant something else. And was Mr. Ruto still speaking when the crowd reacted in this way?
Yes, I remember when I left there when he was still speaking.
And
I don't know if that transcript's correct. It reads at the moment, I remember when he left there, he was still speaking. The witness may have said that, I didn't quite catch it.
I believe the witness said, I remember when I left there, he was still speaking. And you've said this was a crowd of tens of thousands of ODM supporters. Did you hear Mr. Ruto say anything to the crowd about what he really meant when he used the word grabbers?
No, he never...
Again, I'm sorry. I hope I'm not being over-intrusive. I know the question's been asked and the witness is about to answer, but these are all matters that my friend dealt with in chief. It's just repetition. Going over ground, broken ground largely. If there are questions arising out of anything new that's been said, then obviously this is the appropriate time to raise new issues, but just repeating myself.
No, this is an issue that arose directly out of cross-examination. The word grabbers and the interpretation that was placed on it by counsel. And therefore, the response of the speaker is, we say, pertinent.
Objection overruled. Proceed.
And therefore, I'm asking you, Mr. Witness, when the crowd responded in this way, Kikuyu, go back to Central. Did you hear Mr. Ruto make any statement to the crowd clarifying what he meant?
No.
And where is the ancestral home of the Kikuyu?
Central Province.
Mr. President, that's all I ask the witness. Thank you, Mr. Witness.
Thank you.
Thank you. that will be it for this witness. Witness, thank you very much for being with us and answering the questions in the manner that you have done. We know you traveled a long way to come here. We appreciate your coming to assist us as best you can in our inquiry. You are now discharged as a witness in the case, and we wish you safe travels back. The blinds will come down, and the witness will be escorted out of the courtroom.
May I say a word?
Yes, please.
Yes. Before I go, it is to me that maybe I offended anybody when I came here. I offended maybe anybody by my appearance.
No. Okay, you did not offend anybody.
Yes.
Okay. Sometimes when lawyers ask questions, witnesses may feel that way, but none of the questions that were asked of you were improper and did not suggest at all that you had offended anyone. So you need not worry about that. Thank you.
Okay.
The record, I did not say
Nous sommes en audience publique, Monsieur le Président.
Mr. President, we're in public session.
Your Honour, if I may just, arising out of what my learned friends say, also indicate there's one small matter I would like to raise. I'm in your the court's hands as to when we do that. My proposition would be, though, that my learned friend did advise me approximately 20 minutes before we resumed that this application was coming, I know what it's about, but I don't know the substance. It is a matter which might require some preparation for a response. So might I suggest that if my learned friend is to make that application for the lunch adjournment, that the prosecution might respond after the lunch adjournment so we can at least have a chance to look over what it is he has to say. We are prepared to deal with the issue of the protective measures for the current witness immediately, though. Thank you, Your Honours.
Thank you. You're quite far ahead of us. We do not know what Mr. Ken wants to talk about. But do you have any difficulty with him raising it now?
Your Honours,
I know you've indicated that even if he does raise it now, you will not be in a position to respond immediately.
Your Honours, I have no problem with that. He might want to take some time to respond to what I have to raise too, although I've also only recently informed him of that. So it might be that we can each raise our issues and then have some time to consider and in the interim then deal with the issue of the in-court protective measures.
Your Honour, I'm most grateful. I don't require time. My friend was kind enough to alert me just before the session about the matter that he intends to raise, and I can deal with that, in fact, immediately. So I'm in the court's hands. I would propose to raise my discrete matter now. The prosecution can then, of course, decide with the court's leave whether or not the matter is one that they can respond to immediately, or if they're in difficulties or need to consult with the prosecutor, there'll be no objections if they come back at 2 p.m. With their response, if the court is so minded. But it's quite a discrete issue. And I did raise the matter to the extent I thought necessary and available to me before the court sat.
Proceed, Mr. Khan.
Mr. President,
how many minutes did you say you?
Your Honour, I think probably 10 minutes.
10
minutes, maybe less.
All right.
Your Honour will be aware that before we sat this morning, the President of the Court rendered the decision of the Appeals Chamber in the matter of the prosecution's appeal against the Trial Chamber's decision excusing Mr. Ruto from continuous presence at trial. Your Honour, I was informed, and we've read that decision. The decision, as Mr. President, Your Honours will be aware, upheld the issue of law that was contested, that the Trial Chamber do indeed have the discretion and the lawful authority to waive the attendance of an accused in particular circumstances. And the Appeals Chamber went on to enumerate certain conditions or certain considerations that should inform the Trial Chamber in the exercise of its discretion. Your Honour, very briefly, a pertinent aspect of the decision appears at paragraph 50, which is page 20 of the disposition of the decision of the Appeals Chamber. And what the Appeals Chamber held is that the Appeals Chamber considers, and I quote, that the interests of justice and the psychological well-being of witnesses would not be best served if the trial had to be automatically adjourned in each such instance. A measure of flexibility in the management of proceedings in such circumstances accords with the duty of the Trial Chamber to ensure that a trial is fair and expeditious and is conducted with full respect for the rights of the accused and due regard for the protection of victims and witnesses under Article 64(2) of the statute, and helps to ensure, as mentioned by the United Republic of Tanzania, the Republic of Rwanda, the Republic of Burundi, the State of Eritrea, and the Republic of Uganda, justice in each individual case. Your Honour, the Appeals Chamber, in paragraph 2, detailed certain considerations. Now, Your Honours, I'll come to that in due course with the Court's leave. But I was informed, it came to my attention on Wednesday, that His Excellency the President of the Republic of Kenya is scheduled on Monday and Tuesday of next week to travel to Rwanda for a tripartite conference with the President of Rwanda, the President of Uganda, and the President of Kenya in attendance to discuss security and also infrastructure improvements that are necessary for the region. Your Honour, we have previously addressed the Chamber on the constitutional imperative in the Republic of Kenya, which disallows the absence of both the President and the Deputy President away from the Republic at the same time. Your Honour, what I am asking for, and then I'll come to the considerations of the Appeals Chamber, is that the Court excuse the attendance of Mr. William Ruto on Monday and Tuesday of next week. That's the period when the President will be out of the country. He will come back, the President, God willing, will re-enter Kenya on Tuesday night. That will allow Mr. Ruto to take a flight on Wednesday morning. He would get here on Thursday after Court has finished sitting. And so what I would ask is that the order of the Court, Wednesday night. And so the order of the Court that I would be requesting is that he be excused until Thursday morning. He would come on Thursday morning. Now, Your Honours, what the Appeals Chamber held, and there is a six-limb test, or six-limb considerations that the Appeals Chamber put forward as relevant to a trial chamber in the proper exercise of discretion. Your Honour, the easy one, of course, is that the accused explicitly waives his right to attendance. That's, of course, met. 5.5 was that the individual be fully represented during any period of absence. That, of course, is met. Your Honour, the first point is that absence of the accused can take place in exceptional circumstances and should not become the rule. Your Honour, we say that that would not be violated. Mr. Ruto has been continuously present since the commencement of this case. He has attended all hearings as required by the trial chamber, and the period of excusal is extremely limited, and we say it's for exceptional reasons because it will otherwise, the President of the Republic will not be allowed, in effect, to fulfill his constitutional responsibilities to the detriment of the Republic of Kenya as a whole, and indeed the region, because two other heads of state are involved in this as well. Your Honour, the Appeals Chamber advised that certain alternative measures should have been considered. It doesn't say that there should be no other option. Your Honour, the alternative measures are not available, we say, because the meeting involves heads of state. There is sovereign equality between nations, and it does involve the presidents of Rwanda and Tanzania. This is a scheduled meeting. Your Honour, what I was minded to do, and it may have been a mistake on my part, is I became aware of this on Wednesday. And at that point, we had some discussions, and I was minded, in fact, to ask the Court then to adjourn the hearing for Monday and Tuesday. But because I had been given notice that the Appeals Chamber would render a decision today, I decided that such an application may be moot if the appeal had been dismissed in its totality rather than in part. And so I thought the best and most prudent course would have been to wait for the Appeals Chamber decision to see whether or not an application was required. And it seems, of course, it was. So I became aware of the President's diary on Wednesday. I didn't make the application, but, Your Honours, looking at the various considerations put forward, we say that the various considerations militate in favour of the excusal. Your Honour, the absence is limited as factor 3 in paragraph 2 of the Appeals Chamber decision, and it's limited to the period that is strictly necessary. We're not seeking a blanket excusal. It is for a defined and limited purpose. It will, once that period ends, if the court is kind enough to accede to the defence prayer, Mr. William Ruto will come back to court once again. Your Honour, one of the factors that the Appeals Chamber mentioned was that regard could be had, I'll give you the paragraph in a moment, to the specific witness in effect, and the subject matter of the proceedings that were then transpiring. Your Honour, the next witnesses are not victim witnesses, the witness that will be heard on Monday and Tuesday. It's not a victim witness that would violate the original order of the trial chamber. It's a witness that we say is not, it would not occasion any prejudice to any party for the trial to continue in the absence of Mr. Ruto. Now, Your Honour, the court, of course, may have pause for thought and wonder whether or not the trial should be adjourned if you are minded to see some merit in the application put forward. Your Honour, that is certainly a possibility. But, Your Honour, given what I mentioned earlier in paragraph 50, that the Appeals Chamber themselves, both in this decision and in terms of Article 68, has regard to the welfare of victims and witnesses. We know that a witness is here in the territory of the Kingdom of the Netherlands. Mr. Sang, of course, is also here. And notwithstanding the excusal, both Mr. Sang and Mr. Ruto have a right to an expeditious trial. We would say, on balance, the appropriate course is not to cause disruption. We also know there are ASP issues regarding budgetary constraints on the court. We don't want to waste the court costs. And so what we're asking for is limited excusal to allow the President of the Republic to perform his state responsibilities with other heads of state. That requires the Deputy President's attendance. Once the President is back in the country, Mr. Ruto will get a plane and come back to The Hague. Your Honour, I will say that on Wednesday, and it doesn't actually alter the time frame at all, but it may be relevant to Your Honour's exercise of discretion. On Wednesday, there is also a security meeting.
But, Mr. Ken, you might want to look at Article 72. The reason I say it, I had asked you before we started whether your application is something you want to make in the public, whether you want to make with the shades down. You prefer to make them in public. I look at Article 72 to see if they may have any bearing in when this sort of application is made, and in what forum, and what you may want to
I'm grateful,
discuss. The reason I say that is one word you used before I interrupted you goes straight to headline of Article 72. I don't know if it does.
No,
but
Mr. President, I think I'm most grateful for your vigilance, and it may be more prudent, in fact, to go for a moment into private session. I won't be very long, but with your leave, that probably is the prudent course of conduct, and I'm grateful.
Can we go into private session?
Nous sommes en audience publique, Monsieur.
Officer, we are in open session, Your Honor.
Thank you very much. It has been brought to our attention that the defendant, Mr. Ruto, had granted an interview to a news outlet, in the course of which he made comments on the matters pending before the court. This is a matter that had arisen in the past, and the chamber cautioned that Mr. Ruto is to refrain from making comments to the press on the case pending before this chamber. It has happened again, and counsel for Mr. Ruto explained that it was a mistake, and he, on behalf of Mr. Ruto, apologized without any reservation.